Good morning and welcome to the Court of Appeals. My name is John Tyson, and to my right is Judge April Wood. To my left is Judge Tom Murray. We'll be your panel today. We have one case on the docket for argument, North Carolina Farm Bureau versus Jay Young et al. There is a pending motion on how you wish to divide oral argument. I'll be glad to hear you on that right now.
Yes, Your Honor. My name is Shelby Gilmer on behalf of the defendant, appellant, and cross appellee. We filed a consent motion, consent with North Carolina Farm Bureau's counsel, Mr. Andrew Flint, that since there's an appeal and a cross appeal today,
Right.
and they center on the same central issue, that we be allowed to address both in the first 25 minutes, followed by 30 minutes for Mr. Flint, and ending with 5 minutes for myself.
So you want to reserve 5 minutes for rebuttal?
That's right, Your Honor.
Okay. Any problem with that? Okay, thank you then. With that, we'll hear from the appellant. Good morning. I'd like to thank your indulgence on the brief delay. I apologize for holding you up.
May it please the court. Good morning, Your Honors.
Morning.
As I just noted, my name is Shelby Gilmer, and I'm here with my co-counsel, Derek Adler of the Mecklenburg County Bar, on behalf of the defendant appellant and the cross appellee, Ms. Elma Faircloth, as the administrator of the estate of Mildred Gray Williams.
Would you move the microphone a little closer to you?
Yes.
Thank you.
Is this better?
Much better.
Perfect. This is a case of first impression for this court that will allow it to revisit and apply already established rules of construction to an insurance policy provision exclusion to determine whether coverage exists in a wrongful death action that is arising from the tragic death of Miss Williams, who passed away during a roofing project when she fell through a hole in a roof 15 feet and suffered fatal injuries. Before I move further into the issues, would Your Honors like a brief recitation of the facts?
I think that we understand how the issue, if you wish to explain that in conjunction with your argument, you're welcome to do that. But I think the panel is familiar with the background of the case.
Okay, absolutely. The issue before the court today is whether the trial court erred in concluding that Ms. Williams was an employee of Mr. Jay Young, doing business as Young's Construction Company as a matter of law. This conclusion of law reached by the trial court following a bench trial must be considered de novo. In a similar vein, the cross appeal is dealing with a denial of summary judgment to Plaintiff Appellant Farm Bureau, and that should be heard de novo as well. Following Ms. Williams' passing, her estate filed this wrongful death action against the general contractor on the roofing project. The general contractor, Mr. Young, was insured by a CGL policy that was issued by Farm Bureau. Farm Bureau subsequently filed this declaratory judgment action stating that it had no duty to defend under its employee exclusion, which is on page 20 of the record, that states they have no duty to defend against a suit when it's arising from damages in and out of the course of employment. So in order to understand if the exclusion applies, they would have to conclude that Ms. Williams was in fact an employee of Mr. Young. An employee is defined in the policy on page 41 as employee includes a lease worker. Employee does not include a temporary worker. So if she is a temporary worker, there is coverage available to her or to her estate, and if she's an employee, there is not. A temporary worker, defined on page 43, is a person who is furnished to you to substitute for a permanent employee on leave or to meet seasonal or short-term workload conditions. The lower court determined that she was not a temporary worker, but in fact an employee. The court should reverse the lower court's ruling for two reasons. First, a reasonable person in the context of the insured here, Mr. Young, would not have understood Williams to be an employee of Young's Construction for purposes of his CGL policy. The second is that the definition of a temporary worker is susceptible to multiple reasonable interpretations as shown by the evidence presented in the court below, and thus must be construed in favor of the insured. As a brief background on the rules of construction that will be applied here today, because as noted earlier, this court hasn't really had the opportunity to address this temporary worker definition. And the fundamental principle, as stated in North Carolina Farm Bureau versus Martin by the Supreme Court in 2020, fundamental principle with all of these policies is just like any contract, plain language controls, starting with what does the policy say. If there is a definition and it's clear that can be applied, we can move forward. If it's not, then this court must apply the rules of construction to try to get to the intent of both parties who entered into this contract, both the insured Farm Bureau, the insurer Farm Bureau, and the insured Mr. Young.
Am I correct that Judge Nadolski had to apply the plain and ordinary meaning of employee because it was not defined in the policy? Is that correct?
Your Honor, it was defined, but it was simply defined as including a leased worker, but not a temporary worker. So he did shift to starting with looking at what the dictionary definitions are. However, it is our contention that the analysis shouldn't have ended there. Under North Carolina law, you're supposed to also consider what a reasonable person in the context of the insured would have understood it to mean, consider the character of the business of the insured, without the direct guidance of actually saying this is what an employee is.
Now, did Mr. Young stipulate that Ms. Williams was his employee in the underlying OSHA matter? And that's part of the record too?
Yes, Your Honor. The record does state in the informal settlement agreement that he signed that she was an employee. However, that was not in relation to whether she was an employee under the policy. The definition that OSHA goes by, whether it's under the Code of Federal Regulations or under the NC General Statute for North Carolina OSHA, neither one of those have been adopted by Farm Bureau, and that's Farm Bureau having not defined the term and reaching outside of this contract and trying to pull from OSHA. And even if it was the same, OSHA's settlement is not binding on this proceeding and falls outside of that.
So are you saying that the term employee is ambiguous?
No, Your Honor. I'm not saying that the term employee is ambiguous, but that in order to determine if she's an employee, first looking at the plain language, so going through the dictionary definitions, which usually requires some type of wages, and then going into what a person in the context of the insured would consider it to mean. So, for example, in Cowell versus Gaston County, this court in 2008 dealt with a provision that was titled Surveyors, Engineers, and Architects Liability. Underneath it, in the definition, they used the word inspections. So they the insurer tried to exclude inspectors from this policy, and this court said, just pulling out that word inspection and saying, well, this could apply here because you didn't clearly apply it, it gives too much freedom, and it puts an insured in a position where they can't discern what the limits of their policy was. And here, because I keep referring to context, but to kind of center it a little bit more, is that Mr. Young knew Miss Williams as someone, it's a small town in White Lake, who performed odd jobs for various people. This wasn't someone who, he knew as an employee of Young's Construction.
She was strictly paid by cash wages, correct?
Yes, that's correct. She was strictly paid by cash. It's undisputed. She performed a couple of odd jobs for him in the several years before her passing. However, this was extremely limited. She worked a total of 4 hours in 2017, 2 separate jobs, 2 hours apiece, none that he could remember in 2018, and one prior in 2019. He also described his relationship with her as friendship. He gave her money to help out with Christmas, with presents for her children. And no reasonable person in Mr. Young's context is going to understand their CGL policy to entirely exclude coverage under an employee exclusion provision for someone he knew, that he helped out over the years, cared about, gave a couple of odd jobs.
Are you arguing that employee would have to mean full-time employee?
No, Your Honor. Employee does not have to be a full-time employee. It could be a full-time or it could be a part-time.
Now, the policy, and I'm on page 330 of Judge Nadolski's order, he puts right in there the definitions of lease worker and temporary worker. And the definition of employee in the policy includes a lease worker but excludes a temporary worker. Both those are defined. So how did he get it wrong?
He got the definition of employee wrong by failing to analyze the full context under the rules of construction when he shifted from looking at the dictionary definitions to other jurisdictions interpreting it, which was, to look at that, of course, is important because we didn't have anything on point. But North Carolina rules of construction also require looking at the context of the insured. And the context of this specific day is, and this again is uncontested, is that Ms. Williams showed up, and whether, if we're going to accept that she was going to get paid that day, he had said, you can pick up trash, told her not to go on the roof. But then she goes on the roof against the instruction, so not under the control, and falls through and tragically passes away. And then Mr. Young is told, well, she was working as your construction worker on this roof. However, that being said, even if the court did determine she was getting paid, she was going to work that day, this was in the scope of her work, that alone is not going to be sufficient to exclude coverage for her estate, because the most that can be shown here is that she was working as a temporary worker, which again is not an employee. And if she is a temporary worker, or if there's a reasonable construction of the definition of a temporary worker that she would fall underneath, that coverage would be available to her.
So under the policy, then a temporary worker has to be furnished. And I think that's one of the points of contention as well between the parties, is who did the furnishing. If she's a temporary worker and the definition in the policy requires someone to furnish that temporary worker. Could you address that, please?
Yes, Your Honor. The furnishing is the first prong, so there's showing that she was furnished, and then the second prong that she was furnished for meeting these short-term work conditions. So going to the first prong with the furnished to, this is a word that Farm Bureau has chosen not to define. So kind of starting, again, going through those basic rules of construction that have already been established by this court. American Heritage defined it as to provide with what is needed or desired, or to equip. Merriam-Webster has said to provide what is needed, to supply, to give. These are all examples of to furnish. And the majority of courts that have had the chance to analyze this have almost entirely, there's a few outliers, but pretty much conclusively I had determined there needs to be a third party. You can't furnish without a third party. And Ms. Williams' estate concedes that there does need to be third party involvement, just from the grammar and the definitions of it, that it makes logical sense. However, the definition, even understanding that it needs a third party, does remain ambiguous because it's unclear who that party should be, what their relationship needs to be to the injured party, or what type of action needs to be taken to be considered furnishing an individual.
Since the carrier didn't, or the insurer did not choose to define it, we would have to use the plain and ordinary meaning, correct?
Correct, Your Honor.
And so Judge Nadowski did that. In fact, he said in his order that furnished is not defined. So are you taking issue with the way that, with the definition that he applied to as furnished?
Your Honor, we agree with his definition as far as it requiring a third party to do something, to take some type of action.
Let me ask you this then. Mr. Young had subcontracted with Lockley, with the roofing company to do the work, correct?
Correct.
So why wouldn't he be a third party furnishing her to the subcontractor?
Why wouldn't Mr. Young be the third party?
Yes.
The facts that we have that were presented in the trial court were that he continuously told her he didn't need help on the roof. He didn't need her up there. He'd hired the Locklears, so he wasn't providing her as a third party. It was kind of, like I said, just kind of this background, this relationship that they had, that if she needed some help, he's like, okay, you can pick up some trash.
Would you agree that he furnished her to the work site?
No, Your Honor, because if the work site is Mr. Young's work site, I don't believe he could furnish to his own work site. Maybe if he drove her to another work site or something like that, but this was a project he was the general contractor for, and I don't think this quarter, I'm not sure if there's any case law in point for that, but I don't think he would be able to furnish her to his kind of own job site. It would have to be a third party furnishing to another.
And so that in this facts, the closest person that would come to fitting the third party furnisher would be Mr. Blunt. And are you going to could you address Mr. Blunt's role as a potential furnisher and how you see that?
Yes, Your Honor. Mr. Blunt was Miss Williams' main employer. This is something that Mr. Young has stated, that Mr. Blunt has stated, that Mr. Young met Miss Williams for the first time through Mr. Blunt. She was consistently working for Mr. Blunt throughout the summers and the rental seasons and even in the off seasons. So he kind of had this relationship with her, more of an employer-employee relationship or an agency relationship. He also only, was an employer-employee relationship also in the sense that he only ever paid Miss Williams when she was performing work. When she was mowing the grass, when she was picking up trash at his car wash, he would pay her. It was a very different relationship from Mr. Young's kind of friendship. So he was that third party who already had that type of agency relationship. And importantly, the South Carolina Court of Appeals in 2014 in Canal Insurance Company, when they were discussing who is this third party, who does that need to be, and ultimately concluded it was ambiguous as to who it needed to be. But they did state that there does need to be a third party, but it doesn't have to rise to the level of that third party having an agency relationship or an employer relationship. So our facts here are actually even stronger because this wasn't a friend or a co-employee, but it was her main employer.
Was she driving Mr. Blunt's or Mr. Young's truck when she went to the job site?
Mr. Blunt's truck, Your Honor.
She was in Mr. Blunt's truck. So going back to Judge Murray's question, if he furnished her a truck to provide her to get to the site, why wouldn't he be furnishing her to the site?
Mr. Blunt would be furnishing her to the site.
You're arguing that he was the one that did that, not Mr. Young.
Yes, Your Honor. I apologize if I messed those up. Mr. Young was overseeing the construction work, and Mr. Blunt furnished the truck for her to get to the site.
Did
And
Mr. Blunt have anything to do whatsoever with the work or the contracts being performed at the EMT center or at the job site?
Mr. Blunt did not have a direct relationship with the roofing project. However, there was a history of him loaning her out to Mr. Young when he didn't have work for her to do in 2017 and in 2019. And it was one of the findings as well from the trial court finding 6C that Mr. Young's friend, Mr. Blunt, employed her and had loaned her to Mr. Young for work on a couple of occasions. So they kind of had that prior relationship. But the furnished too, you have to have a third party, and then you also have to have the third party do something.
Can you distinguish this particular case from Gavin? Because it appears as though from the record that Ms. Williams found out about the project apparently like the night before at the fire department and showed up looking for work. I think Gavin addressed a very similar issue. So how would you distinguish this case? And that's where the employee was not furnished to the named insured on the day in question because the employee just showed up to the work site looking for a job, but had maybe previously been employed by this same individual.
Yes, Your Honor. Gavin is a very different situation because the employee there had actually been working for this individual, the insured, for 5 months straight prior to the injury. There was no question of, was he paying her? There was no question of, was he her direct supervisor? He tried a variety of arguments about furnishing himself, or he was a part of a bricklayers union, so he said, oh, the union furnished me. But none of that was kind of sufficient because there just weren't those gray areas of who was actually paying you, did anyone tell you about this? And also the court in that decision based its decision in large part on their workers' compensation laws because the individual in that case had already been paid workers' compensation and they wanted to prevent kind of a double recovery from the insured who'd already had to pay out in that situation. Additionally, that case was heard en banc by the Supreme Court and there still was disagreement on the temporary worker. There was a dissent that 2 of the judges joined. So I don't, that case isn't really comparable to the situation that we have with this case.
But, and so once you go, let's say, check the box, furnished, you still have to replace somebody. And I think the record is not very clear on the second prong of temporary worker under the policy that the temporary worker is a substitute for a permanent employee. There's a lot of silence in the record on that second prong of the temporary worker definition of the policy. Could you address that?
Yes, Your Honor. The record is silent as to that part because the definition of a temporary worker is a person who's furnished to substitute for a permanent employee on leave or to meet seasonal or short-term workload conditions. So in this context, we're not arguing that it's substituting, but that she's been furnished to meet a seasonal or a short-term workload condition. Returning to what type of action has to be taken, that's where this definition falls completely short. It's very unclear what it means to furnish an individual to someone and what type of steps to take, what type of things you need to say where it says, okay, that's enough, you're a temporary worker, you've got coverage. That falls a little bit short, you don't have any coverage. It's very unclear just from looking at that definition, which was what was concluded by the South Carolina Court of Appeals that, okay, I can agree with all these other jurisdictions, there needs to be a third party, that's kind of common sense. But beyond that point, it's not common sense who it needs to be, when it needs to be, and it just allows for the insured not really knowing how to discern the limits of their policy.
Does there need to be a conversation between the furnisher and the person to whom is being furnished? And does there need to be a conversation? Because there is a finding of fact that neither Mr. Young nor Mr. Blunt had a conversation about Miss Williams showing up. Is that a requirement of the furnishing process?
No, Your Honor, that's not a requirement because even if there's not a formal agreement, you can reasonably construct it that someone put you in a position to allow you to take that job, whether it's giving you a truck or furnishing you with what you need to get to that job. And the reason why I say that is because, Farm Bureau has discussed, okay, well, there wasn't a formal agreement. Mr. Blunt, the night before, he mentioned to him, hey, she's available, and said that wasn't enough. However, this definition of temporary worker does not require a formal agreement, and if Farm Bureau had wanted to write that into the policy, they could have, and they actually did when they defined a leased worker on page 42 of the record, which states a leased worker means a person leased to you by a labor leasing firm under an agreement between you and the labor leasing firm to perform duties related to the conduct of your business. Explicitly laid that out. If you want to fall under lease worker, there needs to be an agreement between you and the labor leasing firm that you're going to work for them. That language is entirely left out of the temporary worker definition. So no, Your Honor, I don't believe that there needs to be a formal agreement as long as there is some type of action you could reasonably construe to be furnishing someone. And the second prong is to meet seasonal or short-term work conditions. This prong is clearly met. This was told her she could pick up some trash. I think it was like some styrofoam between pieces of metal. Once that's thrown away, it's over from there. The trial court's judgment incorrectly asserts she wasn't there to meet short-term work conditions because he didn't need her there. It wasn't necessary. He didn't have this strong desire for her to come pick up this trash. But I think the South Carolina case continues to remain instructive in that case because when the insured was contacted and asked, hey, do you need another worker, he just responded, one more probably wouldn't hurt. And that was sufficient to meet it. It wasn't, I really need someone here. It was just, okay, they can perform some work, they can help move this house, she can help pick up some trash, and that was sufficient. It's also difficult to reconcile an opinion that she wasn't needed by anyone and no one needed her there, no work for her to do, and then turn around and say she was working as an employee. It just doesn't necessarily line up for her to be working as an employee of Young's Construction when she passed away, but also no one needed there and no one had a job for her. The issue that remains is that there's no clear parameters to establish who must furnish the worker, what type of action is going to constitute furnishing, or any guidelines that would allow a reasonable person who has a policy like Mr. Young had to understand who has coverage under this and who doesn't, who on this job site is a temporary worker, who's an employee. Some of the parts are more clear, like a leased worker, but temporary worker is not. And for that reason, it's ambiguous. And when there is an ambiguity that exists, where there's words in the policy that are susceptible to different and maybe conflicting interpretations, the court should err on the side of coverage for the insured.
And so this is a general liability policy. The party's intent on establishing coverage under a general liability policy and excluding employees, including leased workers, all this, what do you think the party's intent for even entering into this policy is and excluding all these different types of people who do work? What's the basis of this type of policy, and why were those exclusions in there? How does that affect this analysis?
Your Honor, that's a question that I don't know that I can answer, because a lot of the jurisdictions that have looked at this issue have come down and said the intent of the insurer, it's pretty clear. They're trying to make sure their CGL policy doesn't turn into a workers' comp policy. They're not wanting to cover all of these employees. That's not what this is for. This is to protect the public.
And why is that? And why is this not a workers' comp policy?
It's just two separate policies. This is a CGL policy, so it's trying to remain separate from the workers' compensation policy. However, and I know that there's a case that I'm blanking on the name that has been raised from the 90s from this court that was saying this type of exclusion doesn't necessarily apply to workers' comp. But if that's the case, then what was the intent of Farm Bureau making it, which is something that I can't speak to. I see that my time is up. Thank you.
Okay, you have 5 minutes left, and so whatever else you need to address. Okay?
Thank you so much.
Thank you. Hear from the appellee. Good morning.
Good morning. May it please the court. My name is Andrew Flint, and I'm proud to represent North Carolina Farm Bureau Mutual Insurance Company. We're obviously here today on Farm Bureau's cross appeal as well as the estate's appeal. We've discussed how those issues are substantially the same, both factually and legally. Because summary judgment was followed by a bench trial, and the bench trial resolved all the issues in this case, I'm going to focus on that.
So let me help. That was my first question, Mr. Flint. So the cross appeal on the denial of summary judgment, tell me, in light of the fact that a bench trial was held and you prevailed, correct?
Correct.
What's left of the denial that we should be looking at?
So Farm Bureau's position remains that at summary judgment, the trial court correctly denied the estate's motion for summary judgment.
And that was not appealed, I understand.
It was appealed but abandoned,
Okay.
is Farm Bureau's position on that, because the estate has not advanced any arguments about issues of fact at that stage. They focused on the judgment that followed the bench trial. But Farm Bureau's position, it remains, the court should have granted Farm Bureau's request for summary judgment under 56C for two reasons. One, Mr. Young's settlement agreement with OSHA established that Ms. Williams was an employee under the ordinary meaning of the term. And simply that being that she was going to be paid for her work and working under Mr. Young's direction and control. Farm Bureau concedes that the OSHA settlement agreement does not resolve the issue of whether Ms. Young was a temporary worker or not. There was other undisputed evidence at summary judgment that addresses that question. And so the only evidence about how Ms. Williams came to the job site at summary judgment was from Mr. Young's deposition testimony. At the time of summary judgment, Mr. Blunt had not submitted an affidavit, nor had he been deposed. So we're left only with what Mr. Young said. And Mr. Young said in his deposition that he did not need Ms. Williams to come to work, and that he had not talked to her about the job. Instead, she just showed up at the morning of the job. And so to go back to the definition of temporary worker that we've been discussing here this morning, it requires that someone furnish the worker to Mr. Young to meet a short-term or seasonal workload condition. And so the evidence at summary judgment was that she just showed up. Mr. Blunt wasn't mentioned at all. So Farm Bureau's position is that on that record, with the OSHA settlement and Mr. Young's deposition testimony, the trial court should have concluded, one, Ms. Williams was an employee under the standard meaning of the term, and she was not a temporary worker.
What other evidence other than Mr. Young's deposition was before the trial court on summary judgment?
So
there were cross motions, I understand.
To be slightly more precise on that, the estate filed a motion for summary judgment. Farm Bureau did not file its own separate motion, but it instead requested summary judgment as the non-moving party under 56C. So Farm Bureau submitted a notice of filing at summary judgment that included in it the entire OSHA file. So that had Mr. Laurie's investigative reports as well as the settlement agreement. And then the evidence at summary judgment also included an affidavit from OSHA investigator Howard Laurie that recited how he had talked to Mr. Young following the accident, and Mr. Young had stated to Mr. Laurie that he was going to pay Mrs. Williams for her work that day.
How was the estate's motion supported?
The state's motion was supported with Mr. Young's deposition testimony in which Mr. Young denied employing Ms. Williams. And it is Farm Bureau's position that that deposition testimony is insufficient for Mr. Young to show that he was not going to pay Ms. Williams because the prior OSHA settlement required that she was his employee, that he was going to pay her.
So there's a conflict between what Mr. Young said to OSHA and what he said in his deposition, which sounds like there's a material issue of fact, which gets us beyond summary judgment. Is that a good way to look at that?
Yes, that is a good way to frame that, Your Honor. And I think ordinarily it would be enough to get past summary judgment, but for the fact that the conflict was between the settlement agreement that Mr. Young had with OSHA and his deposition testimony. And the settlement agreement with OSHA wasn't just a settlement agreement. In that settlement agreement, Mr. Young agreed in writing that he would not contest any of the citations or offenses that were listed in that settlement agreement with OSHA or any other tribunal. And so it is Farm Bureau's position that when Mr. Young signed that, it precluded Mr. Young from contesting any of the elements of these OSHA offenses anywhere else.
But Mr. Young admitted or conceded that she was an employee, but didn't concede she was a full-time employee. Couldn't she just be a temporary employee, even under the terms of the OSHA agreement?
So,
Because he didn't employ her regularly, I mean, just occasionally, perhaps seasonally.
correct. And that's where I go back to for summary judgment. The OSHA documents established that Mr. Young was going to pay her.
And that she was an employee in some form.
And that she was an employee in the ordinary sense of the term, and that she was someone working for Mr. Young in exchange for compensation and under his direction and control.
Well, wouldn't that also qualify as a temporary employee if they're working in, the employer is going to pay the employee for seasonal work, they're still working as an employee, even if it's just seasonal. So he was going to pay her that day, but maybe not the next day. Couldn't that then be temporary?
If the Farm Bureau policy did not define the term temporary worker, then maybe that would make her a temporary worker. But the Farm Bureau policy defines temporary worker. And it defines temporary worker as someone furnished to you being the named insured, as a substitute for a permanent employee on leave, or to meet a seasonal or short-term workload condition.
If we find there was a genuine issue of material fact that would cause the suit to go to the bench trial, then does that resolve that issue?
That resolves that issue, and then we go to the bench trial, and
I'm not asking for concession. I just want to make sure,
yes,
as we look at both appeals, what we're really focusing on the cross appeal and the denial. And if it was not subsumed in the final judgment.
It was totally subsumed within the final judgment. The final judgment resolves all issues in the case.
And if we find there was an issue of fact as to her, the type of employee she was, that would be sufficient to support the denial?
Yes, Your Honor, assuming that you did. And that takes me to the bench trial and the final judgment. Before I get into this issue about employee or temporary worker in that context, I want to address briefly the appropriate standard of review as to the judgment. The estate has argued that it's a de novo standard of review. As this court knows, there are different standards of review for findings of fact at a bench trial and conclusions of law at the bench trial. And Judge Nadolski made both findings of fact and conclusions of law. Those findings of fact are binding on appeal if they're supported by any evidence in the record, and Judge Nadolski was obviously free to make credibility determinations and did so. Those credibility determinations cannot be revisited here on appeal.
And the bench trial was consented to by all parties, correct?
Yes, Your Honor. No one asked for a jury trial. So at the bench trial, I'm going to focus kind of separately on the issue of whether Ms. Williams was an employee and whether she was a temporary worker. Judge Nadolski correctly determined that employee is defined to include a lease worker but not a temporary worker, and explained in detail in the judgment that that definition does not restrict the ordinary meaning of employee beyond saying it doesn't include temporary workers defined by the policy. So what he did appropriately is look at the ordinary meaning of the term employee and consulted standard dictionary definitions, as this court has instructed our courts to do on a regular basis. And those dictionary definitions all refer to an employee as someone who works for compensation. In addition, he looked at Black's Law Dictionary, which similarly explains that an employee is anyone working for compensation and under someone else's direction and control. Consistent with those definitions, he looked at cases from other jurisdictions that similarly defined employee. And then he took his findings of fact, which are all supported by evidence of record and credibility determinations, and determined that the finding of fact was that Ms. Williams was going to be paid for her work, and that was based on OSHA investigator Howard Laurie's testimony that is detailed in the judgment and in the record. There was an affidavit from Mr. Laurie from the trial court that was, from summary judgment, that was also in the record at the bench trial, and then Mr. Laurie appeared in person and testified. And he said three critical things. First, the day of the accident, that afternoon, he talked to Mr. Young over the phone, and Mr. Young conceded that he was going to pay Ms. Williams for her work. Mr. Laurie further explained that the next morning, so the day after the accident, they met at the accident site, and Mr. Young again said to Mr. Laurie that he was going to pay Ms. Williams. So based on that, he established jurisdiction and proceeded with the investigation.
Let me ask you this, Mr. Flynn. Was there any evidence that Mr. Young compensated the estate for her work the day she died, or if there were funeral expenses paid by Mr. Young?
No, Your Honor.
Either way, there's no evidence.
There was no evidence that he paid the estate or the fuel expenses for Mr. Blunt's truck.
Now, there was evidence in the record where the decedent's family asked that she be listed as a full-time employee of Mr. Young in the obituary.
Yes, Your Honor.
How did Judge Nadolski, how did he review that evidence?
It's not reflected in the judgment, if I recall correctly, Your Honor. I don't think it mentions that at all.
Does that have any consequence one way or the other?
I think it's additional evidence that Ms. Williams was an employee of Mr. Young.
So we don't really have a dispute if she was an employee. It was the type of employee, correct?
Correct. Based on Judge Nadolski's findings of fact and his credibility determinations.
Which we're bound by.
Correct. And that was very simply, there was other evidence that Ms. Williams was an employee, but he focused on two pieces of evidence, Howard Laurie's testimony and Mr. Young's testimony. And he said, there's a conflict between those two things. I don't find Mr. Young's testimony on that issue to be credible. So he accepted Howard Laurie's testimony as credible, established that she was to be paid, and then went on and applied that fact to the ordinary meaning of employee, which was someone who was being paid for their work and under someone else's direction of control. Judge Nadolski made additional findings of fact that Ms. Williams was working under Mr. Young's direction and control, particularly his instruction to her 3 times not to get on the roof. And as Judge Nadolski pointed out correctly, the ordinary meaning of employee is not restricted to full-time workers. It includes any part-time worker, and it doesn't exclude people who work sporadically or casually. The question very simply is, are you being paid to work for someone who controls your work? And she was, under all of the evidence as found by Judge Nadolski and supported by the record.
Mr. Blunt's testimony was before Judge Nadolski at the bench trial, correct?
Yes, Your Honor.
How did he reconcile the difference in the testimonies between Mr. Blunt and Mr. Young?
I'm not sure that he viewed Mr. Blunt and Mr. Young's testimony as different. I think he viewed them as consistent and reconciled them. And that really gets to the temporary worker issue and the question of whether Mr. Blunt furnished Ms. Williams to Mr. Young. And so I think the evidence on that in the form of Mr. Young's testimony was he subcontracted the entire job to Willie Locklear, so he didn't need anyone to work. And Mr. Young said repeatedly in his deposition, which was before the trial court, and again at trial, that he didn't contact Ms. Williams to show up the day of the job. He didn't call her, he didn't text her, he didn't know she was coming. She just showed up the morning of the accident looking for work. Mr. Young knew that she needed money and agreed to let her pick up trash around the site.
Do you know, I'll go back to an earlier question, was there any evidence to support that Mr. Young did in fact pay the estate for the work she did that day?
No, Your Honor.
One way or the other? We don't know.
No evidence one way or another. And I think the key point on that is Judge Nadolski found that Mr. Young intended to pay her. And the intent to pay her is controlling rather than whether he paid her estate or not after her death. It was the intent on that. And so to go back to Mr. Blunt, his testimony was that he was at the beach for the month of October, which is the month this accident happened, that he had a car wash in White Lake, and that he had Miss Williams going by the car wash every morning to empty trash cans and clean up. And he further testified that her car was broken down, in fact left at one of his pieces of property, and he knew she needed money to fix her car. And he loaned her his work truck so that she could get to the car wash and go to any other job that she may find. Mr. Blunt did not testify that he specifically loaned Miss Williams this car to get to the roof project. In fact, his testimony was that Mr. Blunt and Mr. Young talked about this job. Mr. Blunt mentioned to Mr. Young that Miss Williams was available if he needed her. But Mr. Blunt further testified that Mr. Young didn't respond to that by saying that he needed Miss Williams. Mr. Blunt also continued to say that he never talked to Miss Williams about this job. So the evidence was undisputed that Mr. Young never talked to Miss Williams about this job, and that Mr. Blunt never talked to Miss Williams about this job. So if we go back to the phrase furnished to and the requirement that a third party actually do something to provide Miss Williams to Mr. Young, there's no evidence that any third party, including Mr. Blunt, did anything to provide Miss Williams to Mr. Young. Mr. Blunt gave Miss Williams a truck to get to any job she could find, not to get to this job. And we submit that...
Does that matter?
I think it matters that he didn't give her the truck to get to this job. But what's more important...
But he gave her the truck to go to any work she could find.
Correct.
And this testimony support that.
Correct.
So, I mean, this was a job she found.
Correct.
And she drove the truck there that day.
Correct. But this requirement, furnished to meet a short-term workload condition, it requires that a third party actually do something to provide a worker to Mr. Young, and that the worker be provided to meet a short-term workload.
So the fact that he provided her the means to get to the job is not determinative. Is that correct?
The question is whether he discussed this job with her in some way and then said, Mr. Young needs you, go work at this job. If you look at the number of other cases from other jurisdictions in which they found that someone was furnished to an insured, there was always a conversation or action by the person doing the furnishing that directly led to the worker going to the job site for the job in question.
It's not a passive, it's
Correct.
not a passive furnishing. I
It
think
isn't.
that's what the facts, based on the other jurisdictions.
Exactly, Your Honor. It's something more than just giving them a means to get there. It's saying there is this job, this person needs you on this job, go to this job.
So the giving the truck plus the conversation, and she's available if you need her. I mean, we're talking about degrees is what we're talking about, right?
Correct.
But even taking everything as true, your contention is it's not enough.
Correct. Because no one, either Mr. Blunt nor Mr. Young, ever told Ms. Williams about this job or told her that Mr. Young needed her on this job.
But obviously, both of them were aware that she was aware of and evidently had some intention to go there. Why would a conversation have taken place? She's available if you need her. So I know she found out about it by going to the fire meeting, but it seems, excuse me, that there was some conversation between Mr. Blunt and Mr. Young.
Mr. Blunt and Mr. Young went on vacation together at Myrtle Beach.
They're close friends.
Close friends, and Ms. Williams had worked for both of them in the past. I think it was a casual conversation, and Mr. Blunt knew that Ms. Williams was looking for work to make money to fix her car. And I think it was a casual conversation in that context if the evidence of record is read in context.
And she had worked for both of them on and off, correct?
Correct, Your Honor. But there's just simply no evidence that either one of them discussed Mr. Young having a need for Ms. Williams on this job or Mr. Blunt doing something to get her to this job.
Now, I know that Canal Insurance is a South Carolina case, so it's at most persuasive. But could you address their analysis that is persuasive evidence in this case, and also Judge Wood's reliance on Gavin?
Yes, Your Honor. So starting with the South Carolina case, Canal, that case found, like every other case, that furnished to means a third party has to provide the worker. They didn't dispense with that requirement. What they said is it was unclear who the third party was. Does it have to be a leasing agency? Does it have to be someone with a formal agency relationship? Does it have to be some independent party, or does it have to be a coworker? But the facts here are materially different because in the Canal case, this coworker called the worker and said, we want you to come to the job that day. That was action by the coworker that directly, not passively, caused the worker to end up on the job site. Here, there's no evidence that Mr. Blunt or the other young worker, Chris Lee, called Ms. Williams up and said, we need you to get to this job. Those facts are what distinguish this case. So it is irrelevant on the facts we have that it may be unclear who the third party must be because there is no third party that did something to get her there.
Third party would have to be Mr. Blunt.
Correct, and he didn't directly and actively do anything to get her there. As to Gavin, Farm Bureau submits that Gavin is directly on point with this case and instructive. Ms. Williams furnished herself for this job just like the worker did in Gavin. That is the key similarity between these cases. It doesn't matter that the worker in Gavin had a longer duration of employment because, as we've discussed, part-time or casual employment counts. It very simply stands for the proposition a worker can't furnish themselves. That's well-reasoned, consistent with the policy language, the ordinary meaning of those, and that's the situation we have here.
So I think you can speak to parties' intent with regards to the contract formation of this liability policy on why there is an exclusion for employees and the additional addressing of what the rule of a temporary employee versus a leased employees. Could you speak to why these employees are excluded from a party's intent perspective as representing the insured?
Yes, Your Honor. And just to be clear, Farm Bureau's position is that the intent is found in the language of the policy, and that's what we're construing. But to step back from that, Farm Bureau issued Mr. Young a commercial general liability policy. That's what they issued, that's what the premiums were for, and those are the premiums that Mr. Young paid. Farm Bureau did not issue a workers' compensation policy or an employer's liability policy to Mr. Young. So a CGL policy covers the insured, so Jay Young, against the risk that they're going to be liable to a third party for either bodily injury or property damage. So it's insuring Mr. Young against the risk that someone other than his employees gets hurt, files a lawsuit against him, or that he damages someone else's property and they sue him. And that's made clear by two exclusions in the policy. First is exclusion 2D. That's the workers' compensation and similar laws exclusion. If I can put up on the real quick, just to make sure we're clear. Okay, so exclusion 2D is the workers' compensation and similar laws exclusion. That specifically provides that the CGL policy doesn't cover any obligation that Mr. Young may have under a workers' compensation or similar law. And then there's the employer's liability exclusion. And that doesn't depend on whether there's workers' compensation coverage or not, as this course said before in the Fieldcrest Cannon case. It depends on the issue of whether the injury is to an employee. So those two things make clear that we're insuring Mr. Young against the risk of injury to third parties. Mr. Young wasn't required to have workers' compensation coverage because he employed less than 3 people. And there was a workers' compensation claim made, and he denied it on that basis. But that doesn't mean Mr. Young couldn't have bought workers' compensation coverage. He could have still bought workers' compensation coverage that would have protected him against the risk of injuries to his employees. Mr. Young could have also purchased a separate employer's liability policy that's designed for that type of risk. They have different premiums. There's no evidence in the record that Mr. Young bought an employer's liability policy. The record is clear he did not have workers' compensation, if I remember correctly on that. So Farm Bureau's position on that is the exclusions 2D and 2E make clear that this policy does not cover Mr. Young against the risk of injury to his employees. That's what a workers' compensation or employer's liability policy is for. He didn't purchase the workers' compensation, and there's no evidence of employer's liability. So the insurance coverage questions here don't determine whether the estate has a remedy against Mr. Young. They determine whether Farm Bureau has an obligation to defend Mr. Young or to indemnify him to any liability he may have to the estate. Because it's a CGL policy with this exclusion, it simply doesn't cover that, and Mr. Young has to bear that risk himself. And unless your honors have any further questions.
Mr. Smith, you would introduce your co-counsel at the table for the court?
Yes, Your Honor. I have with me today my colleague Angela Craddock, who has assisted on the briefs in this case. Thank you.
Good morning, Ms. Craddock. Thank you. Rebuttal? First question while you're coming up, is there really anything, I would presume that you would agree there's not really much on the denial of summary judgment, that there was genuine issues, the trial court could find there were genuine issues of fact, summary judgment?
Your Honor, as far as deciding if she was a temporary worker, there was no dispute of material fact.
She was an employee.
Yes, yeah.
There may have been a dispute over the status, which didn't sufficient to go to trial.
Yes, Your Honor. The one disputed material fact was really whether she was getting paid or not. Everything else was pretty much agreed on, but that was kind of a core issue that ended up pushing it forward. But I wanted to briefly respond regarding the cross appeal, since I didn't get to touch on that as much. But during the cross appeal, Farm Bureau relies almost entirely on this OSHA settlement. And I just want to remind the court that OSHA's definition of an employee is not the policy's definition of an employee. This court's role is to. I apologize.
Are you continuing it's broader? OSHA's definition is broader.
Yes, Your Honor. And that when analyzing this, you start with the plain language, and if that doesn't make sense, you follow the rules of construction, looking at the definition in the dictionary, looking at the context of the insured, looking at the type of business. You follow those rules that we have decades and decades of cases that are establishing. You don't go to the Code of Federal Regulations and expect that the insured is going to know that that's what it is. However, even if the court were to say, OSHA settlement's binding, said she was an employee, that's the definition that applies, she could still be found to be a temporary worker. And Mr. Lurie testified to that at trial, that the OSHA definition is very broad, and even if she was a temporary worker that day, she was supplied by Mr. Blunt, it would still fall within that parameters.
Do you agree with Mr. Flint, that we are bound by Judge Nadowski's findings of fact?
Yes, Your Honor, we are bound by his findings of fact, but not in their application to the rules of law and the conclusions that he reached.
So you would have to challenge his conclusions of law then, correct, or the application of those findings to the conclusions?
Yes, Your Honor. It's the estate's contention that neither the analysis of employee nor of the word temporary worker was correct under North Carolina law. So the issue is with the application as opposed to, making this an issue of credibility and weighing these different things. It's really about coming down to looking at the policy, what does the policy say, and where are we reaching for these other definitions. And if Farm Bureau had wanted to have this incredibly broad term, they could have, and they have, and I think it's on page 35, they defined a hired worker as essentially anyone working for the insured. So you can put that in there if that's what they had wanted, but they didn't. They added this temporary worker definition, which, to Judge Murray's point about trying to get to the intent of the parties, it's very blurry. And if Farm Bureau can't actually articulate why it's in there and what it's for, it's difficult for the insured to discern who is covered, like where's my protection, where am I going to potentially face direct liability when I'm paying premiums for this CGL policy. In conclusion, the plaintiff appellee, the insurer, was the one who drafted this policy. They chose which words to define, they chose which words to not define. North Carolina courts have continuously held that if the drafter is choosing words that are confusing, they can be discerned in different ways, but reasonable and conflicting ways, then all who may by any reasonable construction of the word be included within the coverage afforded by the policy should be given that protection. For the reasons stated and briefed to the court and an oral argument, the defendant appellant respectfully requests this court to reverse the trial court's trial verdict and to affirm the trial court's denial of Farm Bureau's motion for summary judgment.
One moment. I have one question. Is your firm representing both Mr. Young and the estate?
No, Your Honor, just the estate.
Just the estate. And would you also introduce your co-counsel at the table, please, to the court?
Yes, Derek Adler of DAS Law Group is my co-counsel, and he also only represents the estate.
All right. Welcome to the court. Thank you.
Thank you so much.
Okay, the case is submitted. We thank both parties for very good oral arguments. Again, we do apologize for the brief delay this morning getting started. And with that, would you please adjourn?
Please, Marvin.